Welcome to Essential Libertarianism, selected readings from voluntarist.com. Essential Libertarianism is voluntarism. Let's reclaim the anti-political heritage of this philosophy together. The essays and books we read in this show will bring us closer to the state-free voluntary society that we desire. Let's begin the journey.
The Ethics of Voting, Part 1, by George H. Smith. 1. Introduction. A detailed libertarian critique of electoral voting is long overdue. Political libertarians, i.e. those who support the effort to elect libertarians to political office, are usually silent on the moral implications of electoral voting. When challenged, they typically dismiss moral objections out of hand, as if the voluntarist, i.e. anti-voting case, deserved nothing more than a cursory reply. This situation will probably change in the near future. The issues raised in voluntarist arguments are far too important to be discarded without careful consideration, even if one ultimately rejects voluntarist conclusions. This is especially true for those political anarchists, if I may use that curious phrase, who support the Libertarian Party. If it is at least comprehensible why minarchists, advocates of minimal government, support a political party, the spectacle of political anarchists is far more perplexing. Hence, this essay is directed primarily at political anarchists, though some of the material is relevant to minarchists as well. The purpose of this essay is to explore the moral implications of libertarians, especially anarchists, holding political office, running for political office, or assisting those who do, primarily through the vote. The ethics of voting cannot be divorced from the key question of what one is voting for. And this, as I shall argue, cannot be divorced from the institutional framework in which the voting occurs. This essay is directed to fellow libertarians who are familiar with the standard debates in contemporary libertarianism, such as that between minarchism and anarchism. I must also assume that the reader is generally familiar with the basic approach of voluntarism. If not, my essay Party Dialogue should be consulted, along with the other essays in the Voluntarist series. Moreover, standard terms in the libertarian lexicon, for example, invasion and aggression, which I use synonymously, are not defined in this essay. Here again, standard libertarian works should be consulted, such as various books and essays by Murray Rothbard. A term that may generate some confusion is electoral voting. This means voting for the purpose of placing someone in a political office. It does not refer to other kinds of political voting, such as voting on particular issues in a referendum. This requires a somewhat different analysis. Hereafter, unless otherwise noted, the simple term voting shall be used to mean electoral voting. Since this essay is to appear in installments, I must beg readers' pardon if some problems remain unsolved at the conclusion of each part. The theory of voting has been so neglected that it is difficult to explore its moral implications without first laying a good deal of preliminary groundwork. Some pro-voting arguments are based on different premises and actually clash with each other when employed by the same person. Other pro-voting arguments appear decisive, but they retain this appearance at the expense not only of voluntarism, but of principles common to all libertarian theories, especially anarchism. These kamikaze arguments attack voluntarism by undercutting the foundation of libertarian political analysis, thus exploding political arguments later. For one libertarian to use a kamikaze argument against another libertarian is somewhat indelicate, to say the least. The theory of voting should be investigated within a broad framework of political and legal theory. This plunges us into complex and troublesome areas, like principal-agent relationships, accessories before the fact, aiders and abettors of crime, and so forth. I do not presume to have solved the problem these concepts create for libertarian theory, but libertarianism undeniably depends on some notion of accountability for persons other than those directly involved in criminal or aggressive acts. Libertarians generally agree that the driver of a getaway car is liable for a bank robbery, even if he did not personally wield a gun or threaten force. Similarly, we hold legislators accountable for their unjust laws, political executives accountable for their unjust directives, and judges accountable for their unjust decisions. We do not exonerate these individuals just because they legitimize their actions under the mask of law. Yet political and bureaucratic personnel rarely participate in law enforcement. They do not strap on guns and apprehend violators. That is left for the police. Clearly, therefore, the libertarian, anarchist condemnation of the state as a criminal gang rests on the view that criminal liability can extend beyond the person who uses, or threatens to use, invasive force. Most of the individuals in government, though not directly involved in aggression, nevertheless aid and abet this process. Libertarian theory would be irreparably crippled without this presumption. If criminal accountability is restricted only to direct aggressors, then the vast majority of individuals in the state apparatus, including those at the highest levels of decision-making, must be considered non-aggressors by libertarian standards and hence totally innocent. We could not even regard Hitler or Stalin as aggressors, so long as they did not personally enforce their monstrous orders. The only condemnable person would be in the police, military, and in other groups assigned to the enforcement of state decrees. All others would be legally innocent, though we might regard them as morally culpable. Few libertarians are willing to accept this bizarre conclusion, but it automatically follows if we refuse to incorporate within libertarian theory some idea of vicarious liability defined by Black's Law Dictionary as indirect legal responsibility. For example, the liability of a principal for torts and contracts of agents. Libertarian theorists have virtually ignored vicarious liability in three respects. First, they have rarely acknowledged it as an implicit underpinning in the libertarian, especially anarchist analysis of the state. Second, they have neglected to provide a thorough study and justification of it. And third, and most relevant to this discussion, they have not examined its implications for the theory of voting. I shall not attempt to defend a theory of vicarious liability here, despite the crucial need for such a defense. Because I am addressing fellow libertarians, most of whom accept some version of this principle, I shall accept a vicarious liability as a given within libertarian theory and proceed from this foundation. Libertarian theory in general, and anarchist theory in particular, would tread perilously close to incoherence without this presumption. Given this fact, it follows that voters, in some cases at least, are deemed accountable by libertarians for the results of their votes. For example, legislators who vote for victimless crime laws. And this liability attaches despite the fact that the voters do not directly engage in aggression or explicit threats of aggression. It is incongruous, therefore, for a political libertarian to profess bewilderment that even a prima facie case against voting may exist, on the ground that voting is obviously a non-aggressive act. If voting per se is deemed non-aggressive, if the voter is never accountable for what occurs afterwards, then this attack on vicarious liability succeeds in smashing voluntarism at the considerable expense of rendering incoherent the libertarian analysis of the state. Thus do kamikaze arguments succeed. The libertarian who seriously believes that voting is always non-aggressive, how, he asks, can pulling a lever in a voting booth constitute aggression? Is led by his own logic to conclude that voting for any candidate is permissible by libertarian standards, regardless of what the aspiring politician promises to do while in office. A candidate might promise to imprison all redheads in slave labor camps, or to order the execution of all Catholics on sight. But on a strict non-accountability theory of voting, the voter who places these politicians in office are in no way liable for their criminal acts. And since, as political libertarians like to remind us, libertarian theory forbids only aggressive acts, there would be nothing inconsistent in a libertarian voting for these power seekers, because all voting is, by definition, non-aggressive. Moreover, the successful libertarian politician would find it impossible, qua officeholder, to violate libertarian principles while in office. If voting is never aggressive, then the libertarian legislator can never be aggressive, and hence unlibertarian, regardless of what he votes for. Would a libertarian legislator who voted for a draft be regarded by members of the Libertarian Party as having acted contrary to libertarian principle? Most certainly. But if libertarianism forbids aggressive acts only, and if voting can never be an aggressive act, then in no sense can the pro-draft legislator be accused of behaving in an anti-libertarian fashion. Political libertarians who endorse a non-accountability theory of voting will have to grapple with its many paradoxes. After its implications are understood, it is unlikely to find many defenders. Such political libertarians already concede that a voter may be held accountable. For example, Jeff Hummel, a prominent anarchist and supporter of the LP, maintains that any legislator who votes for an unjust law is in fact one of the actual aggressors. Does this argument extend a step further back? Do voters who place these politicians in power share liability for the resulting injustice? Unfortunately, this is one crucial question among many on which political libertarians remain silent. I have argued briefly that the voluntarist case against political voting cannot be dismissed as prima facie absurd by political libertarians. This is because political libertarians share with voluntarists a theory of vicarious liability on which the case against voting is built. Deny vicarious liability, and political libertarians will be hard-pressed to retrieve their own theory from the wreckage strewn about by their kamikaze attack. Of course, to establish the prima facie possibility of the voluntarist case does not cinch the argument. Many more arguments and principles need to be considered, but we have at least cleared a path along which the rest of the article may travel. Voluntarism is perhaps the most important libertarian philosophy, and this podcast is designed to give you a piece of that. But there is a ton of other information out there on the topic of voluntarism. This is why we've compiled an easy list of great voluntarist resources in one location as a one-stop shop for the very best voluntarist content out there. From authors such as Lysander Spooner, Henry David Thoreau, Etienne de la Boétie, Larkin Rose, Carl Watner, Herbert Spencer, and more at essentiallibertarianism.com/books. The best part is that every time you buy something from that list, you help support this show without having to pay a penny extra. So go to essentiallibertarianism.com/books today to start or accelerate your journey to the only non-political, non-violent strategy to achieve a free society and help us delegitimize the state. essentiallibertarianism.com/books. 2. The burden of proof. Before proceeding to an analysis of electoral voting and the arguments pro and con, it may prove helpful to establish some procedural guidelines. Foremost in any argument is the burden of proof. Who assumes the burden of proof in a given dispute? Which side must produce the preponderance of evidence and/or arguments in order to resolve the case? Most importantly, if the responsible party fails to meet the burden of proof, then what is the status of the dispute? In the voting debate, it is usually assumed that the burden of proof rests with the voluntarists, that is, the opponent of voting. If the voluntarist claims that voting is inconsistent with libertarianism or anarchism, then he must substantiate his claim. He must show that electoral voting actually falls within the category of actions known as invasive or aggressive. Failure to accomplish this acquits the political libertarian, or the political anarchist, of all charges. This procedure seems reasonable. To condemn voting as improper is a serious charge, after all, and it appears that the voluntarist should assume the burden of proof if he expects to be taken seriously. We see a parallel in legal theory, where a man is presumed innocent until this presumption is defeated, that is, until the defendant is proven guilty beyond a reasonable doubt. The legal presumption of innocence determines where the burden of proof rests. Failure to provide sufficient proof means that the presumption remains where it began. The defendant is innocent. The legal analogy is accurate in one respect. It points out that the burden of proof is fixed according to the basic presumption of the argument. If, as we have seen, an accused man is presumed innocent, then the onus falls upon his accuser to defeat this presumption. A presumption functions as a starting point in a dispute. From the legal analogy, however, it does not follow automatically that the political libertarian is analogous to the defendant, and thus it does not follow that the burden of proof lies entirely upon the voluntarist. Indeed, in dealing with anarchism, the principled rejection of the state, I maintain that there is a presumption against political office holding and therefore a presumption against voting for political office. Thus, the political anarchist is the one who must defeat the basic presumption. When two anarchists debate the ethics of voting, it is the political anarchist who assumes the major burden of proof. It is the political anarchist who must demonstrate to the voluntarist why voting, an overt participation in the political process, is not a violation of their common anarchist principles. Let us examine this claim in more detail. Voluntarists are more than libertarians. They are libertarian anarchists. They reject the institution of the state totally, and it is this element that is not contained, explicitly at least, within libertarianism. Libertarian theory condemns invasive, rights-violating acts and says that all human interaction should be voluntary. All libertarians, whether minarchists or anarchists, accept this. It is the defining characteristic of a libertarian. Libertarian anarchism professes not only the non-aggression principle, but the additional view that the state is necessarily invasive and should thus stand condemned. Libertarian anarchism combines the libertarian principle of non-aggression with a particular analysis of the state, an analysis not shared by libertarian minarchists. It is the premise of non-aggression, coupled with an institutional analysis of the state, that leads to the rejection of the state by the anarchist as inconsistent with libertarian principles. The above reference to institutional analysis is critical. One cannot progress from libertarianism to anarchism without an intervening argument. A principled rejection of the state does not necessarily follow from the non-aggression principle, unless one can also show that the state is necessarily aggressive. This latter point, the anarchist insight into the nature of the state, is the minor premise required to justify anarchism. Major premise: libertarian theory condemns all invasive acts. Minor premise: all states commit invasive acts. Conclusion: libertarian theory condemns all states, or governments. I use the term interchangeably. This syllogism illustrates the difference between simple libertarianism, articulated in the major premise, and libertarian anarchism, articulated in the conclusion. The transition to anarchism is realized through the anarchist insight, articulated in the minor premise. This insight is what all libertarian anarchists share with fellow anarchists. It is also what distinguishes libertarian anarchists from their minarchist cousins. Minarchists qualify as authentic libertarians so long as they believe it possible for their minimal state to remain non-aggressive. The minarchist, like the anarchist, accepts the non-aggression principle, but the minarchist does not accept the anarchist view of the state. This controversy over the minor premise leads to different applications of the non-aggression principle to the state. Whether this stems from a definitional dispute or from something more substantial need not concern us here. The minarchist issues a challenge to all libertarian anarchists, political and voluntarist alike. Prove that all governments are invasive. Demonstrate that the state, by its very nature, must violate individual rights. The anarchist responds, as indicated earlier, with an institutional analysis of the state. He avers that institutional features of the state, such as the claim of sovereign jurisdiction over a given geographical area, render the state invasive per se. This invasive trait persists regardless of who occupies positions of power in the state or what their individual purposes may be. The anarchist insight, in other words, is not arrived at inductively. The anarchist does not investigate every employee of every state, determine each individual to be an aggressor, and then generalize from the individual to the institution. On the contrary, the state is assessed first, qua institution, according to constant structural features inhering in all governments. This institutional analysis leads to the anarchist insight, after which particular individuals within the state are considered to be part of a criminal gang, owing to their participation in the exercise of state power. To put it another way, for anarchism, the individual does not taint the institution. Rather, the institution taints the individuals who work within it. It is because the nature of the state, as an institution, renders it irredeemably invasive that we condemn particular offices within the state apparatus, and hence particular individuals who occupy those offices. Such individuals aid and abet state injustice, even though they may not personally commit aggressive acts. It is necessary to understand that the institutional analysis sketched here is vital to all theories of anarchism, including political anarchism. This kind of institutional analysis must be valid if anarchism is to have a solid footing. It is simply impossible for anarchists to derive anarchism from the inductive method described above. It is patently impossible to examine the personal motives and goals of all individuals who comprise the state before we can pass judgment on the state itself. In addition, if this research were undertaken, we would find that the vast majority of state employees never intend to aggress against others, nor do they participate directly in aggressive acts. The inductive method never permits us to bridge the gap between individuals and institutions. Indeed, from a purely inductive perspective, there is no state. Only individuals exist and act. There are no institutions. The state, then, is a fiction, and it is nonsense to refer to the state as invasive or aggressive. Only individuals can invade or aggress, and although some individuals within that organization we call the state may personally aggress, the vast majority do not. To condemn the state per se, therefore, as the anarchist wishes to do, and by implication to condemn all individuals within the state, is flagrantly unjust. It is to besmirch the good names of innumerable state employees who never personally engage in aggression. This methodological objection to anarchism is important, and anarchists, as I have indicated, will be unable to respond adequately unless they defend the approach I have described as institutional analysis. The coherence of anarchism as a theory hangs on this kind of analysis. Why is this relevant to the debate over voting? Because it illustrates that the presumption, and therefore the burden of proof, varies according to whether the voluntarist addresses a minarchist or a political anarchist. Since the minarchist needs not adopt an institutional analysis, he will not view the fact that an individual is an agent of the state as even prima facie evidence of improper conduct. There is, for the minarchist, no moral curse on the state as such, which then filters down to individuals within the state. Working for the state, in other words, does not constitute a presumption of guilt. The individual is presumed innocent until proven otherwise, despite his institutional affiliations. This is why the minarchist is a difficult convert to voluntarism. Usually the minarchist must be brought first to anarchism, which requires that he accept an institutional analysis of the state, and only then to voluntarism. The procedural chasm dividing voluntarists from minarchism is so wide that this intermediate step is ordinarily required. The burden of proof falls upon the anarchist to establish the soundness of this intermediate step. But the situation changes when the voluntarist addresses a political anarchist. Here the anarchist insight, the recognition of the state per se as an invasive institution, is agreed upon by all parties before the argument over voting even commences. Both disputants utilized institutional analysis in order to arrive at their current positions. It is plainly inconsistent, therefore, for the political anarchist to reject voluntarism because it employs institutional analysis. It borders on hypocrisy for the political anarchist to fall back upon the personal intentions of his favorite politicians in order to save them from the anarchist curse, when he has traveled merrily down the anarchist road without ever having regarded personal intentions as significant before this point. If an institutional analysis of the state is good enough to get us to anarchism, then it is good enough to get us to voluntarism. Institutional analysis is not a bridge that can be conveniently burned by the political anarchist after he has used it to cross over to anarchism. It is because of this common acceptance of the anarchist insight that the initial presumption shifts in favor of the voluntarist. The voluntarist and the political anarchists agree that the state is inherently aggressive. From this, it follows that anyone who voluntarily joins the state, who campaigns for office, receives a salary, swears allegiance to the state, and so forth, is at least highly suspect from an anarchist point of view. There is a presumption, a prima facie case, against the political office holder in anarchist theory, and thus against voting for a political office. The burden then falls not upon the voluntarist to show how this officeholder participates in aggression, for both disputants already agree that the state is inherently aggressive and both accept vicarious liability, but upon the political anarchist to show how his favorite officeholder constitutes a valid exception to the general condemnation, the anarchist curse, of the state and its agents. Anarchists agree that the state is necessarily aggressive, which is why they commonly use terms like criminal gang and ruling class to describe the state. But anarchists also realize that the state is not a disembodied entity. Institutions are not individuals. They cannot act in any fashion, much less act aggressively. Thus, if the anarchist analysis of the state is to have meaning, it must refer to individuals who work within the structure of the state apparatus. individuals and their actions considered within a broader institutional framework, prescribed goals, rules, and procedures, combine to form what anarchists mean by the state. Particular offices within the state and the individuals who occupy those offices are assessed according to their importance in directing, supporting, and furthering the institutionalized goals of state power. It is because anarchists regard the state as inherently aggressive that there exists a presumption among anarchists that anyone who joins the state participates in this aggression. The anarchist curse, the presumption of evil, descends from the condemned institution to the individuals who are necessary to maintain the life of that institution. The institution is the skeleton, in effect, which requires the flesh and blood of real people to operate. These people are highly suspect in anarchist eyes, even if they do not personally aggress, because they are the components required to translate the institutional aggression of the state into concrete reality. The anarchist presumption against agents of the state, like all presumptions, is defeasible. It may be that the political anarchist can argue for a valid exception to the general rule. He may be able to explain why we should regard all politicians as members of a criminal gang except those politicians with good, that is, libertarian intentions. Personal intentions were not previously considered relevant to the anarchist analysis of the state, but the political anarchist may have uncovered new information that will convince his voluntarist colleague. The political anarchist may thus be able to overcome the presumption, the anarchist curse, that makes his case seem initially plausible. The idea of an anarchist politician does seem counterintuitive at best. In our dispute between the voluntarist and the political anarchist, therefore, the presumption is on the side of voluntarism, and the political anarchist assumes the burden of proof. Anarchists of all persuasions have traditionally rejected electoral politics, and with good reason. This seems, after all, to be an essential part of what anarchism means. This is why I wrote in Party Dialogue that libertarianism must stand firm against all senators, all presidents, and so forth, because these officers and the legal power they embody are indispensable features of the state apparatus. After all, what can it possibly mean to oppose the state, unless one opposes particular offices and institutions in which state power manifests itself? With the preceding introduction material, we're now able to undertake a systematic analysis of voting. Some of the issues discussed thus far raise problems far too complex to be resolved without further discussion. These will be addressed in more detail in subsequent parts of this essay.
Thank you for listening to Essential Libertarianism. You can check out the archives of all of our episodes at essentiallibertarianism.com. And you can subscribe to future episodes on any podcatcher, including Apple Podcasts, Stitcher, Google Play, and more. This has been a Pax Libertas Productions podcast.